So now, Mr. Simbat, is there anything else you want to add?
Yes, I've got some brief points to make. Some partly in answers to the court's questions, in fact. So to prove that, in relation to the first of my points, you did want some information about what the family relationships were and who was in this country. And
Yeah, I don't know. Thank you very much. I don't know a huge amount of detail, but I assume there's family.
Well, there is there are two sisters and a brother here who live in this country, but they live in London and in Southend. So they're not in Manchester.
In Hasidic communities.
Yes, in the Hasidic communities. And the reason that Mrs. Fixler is here is she had come here essentially when her parents did. Her parents taught or her father taught in a school. His job ended and he went back to Israel in September 2018, and not long after Alta was born, and they stayed here. So in terms of what would have happened in this family and the answer the court raised about where their sort of family are, it's right to observe that in a sense her connection with this country was in that context. While we're dealing with religious identity, it's also right to say that, and obviously we'll hear from we'll hear from the Guardian in a moment, but the Guardian's evidence doesn't actually sort of deal with the profound issues of being from a Hasidic community or the extent to which that makes a difference. And that may be one of the things that's relevant in this case when we come to look at the medical evidence and the medical evidence on pain and so on, that the Guardian didn't herself obtain independent evidence, and there are some cases where that might have happened. And that's,
yes, you made that. Yeah, okay.
Yeah. Yeah. And just in terms of the point, the last point I was on before we rose for the lunch adjournment, which was in connection with what the arrangements are if somebody about being buried in Israel and so on. Generally, if somebody in this community knew that they were going to die, they had a terminal illness or something like that, they would try to travel to Israel to try and secure that outcome. As a matter of reality, and I'm sure my lord and my ladies can understand this point, if somebody dies in this country and they want to be moved abroad in the way that Mr. Justice MacDonald contemplated was possible, there is a very considerable amount of bureaucracy, both in terms of issues with embassies, issues with the coroner in certain cases, and issues in terms of booking airlines and so on. So the process of ending up buried in Israel, if you die here, is a convoluted and complicated one. I'm sure the court could appreciate that for itself.
It is, although I imagine it's something which is not infrequently
My lord, that's
arranged.
Right. And in fact, Mr. De Silva does have some experience of this sort of thing, and he says it's often 3 weeks, and you'd never get it done in less than a week. So
would I be right in thinking that a significant number of the community, elderly members of the community, if able to travel to Israel to die there? That's my understanding. Goldberg is nodding. Yeah.
That's my understanding from Rabbi Goldberg. Yes. So that's so, and of course, with this family, most of the relatives who would be wanting to visit the graves and so on, leaving the parents out for good. We discussed the parents and where they would have wanted to be or whatever. But the other members of Alta's family are primarily those resident in Israel.
Yeah. Yes. Thank you.
That's all I'll say. Thank you.
Anything else, Mr. Thank you. We're very grateful.
Oh, sorry,
thank you very much.
I sat down rather rudely thinking you wanted to see the back of me.
No, thank you. Yes, no, you didn't expect a compliment from me.
Thank you.
Miss Mulholland, thank you again for your skeleton argument.
My lord, in light of the skeleton argument, I don't propose to take your lordship, your ladyship's through that skeleton argument. It is there and it responds to...
It does.
In great detail. And in fairness, by reference in large part to the judgment below.
Yes.
Because it is my submission that judgment is unassailable. It is a very detailed and very compassionate judgment and it factors in all of the elements. Which
Well, I think Mr. Simlet has focused on 2 points, hasn't he? He's focused on the treatment of pain and the treatment of religion, which
Yes.
one might have anticipated was where he would focus. So I expect you're going to do the same.
Precisely so. If I might preface matters, my lord, by speaking about the fresh evidence and submitting on that, because that leads into pain.
Well, you made quite a few submissions, didn't you, on that?
I do, and I accept that lad isn't a straitjacket, and for what it's worth, I accept that particularly in a case of this nature and this sensitivity, your lordship, your ladyships will not have your eyes closed to those matters, and nor would I expect you to. I would expect those matters to be considered in full. That is not to say that they should be permitted in evidence, but my submission doesn't end at the first limb of lad. It doesn't say, well, they were available, they could have been available, and that's where it ends. I go on, as your lordship will have seen in my skeleton argument, to deal with matters of cogency of that evidence, of credibility of that evidence.
Yes, well, you do, and we have those submissions.
Well, I'm grateful. And that flexibility of this court in that approach is mirrored by the flexibility that Mr. Justice MacDonald showed evidentially. He showed a flexibility in his approach when he raised the question of evidential gaps at the end of day 1. And for what it's worth, the Guardian and the Trust, Ms. Holleran and I, have shown flexibility in terms of our approach. You perhaps noticed in my position statement for the substantive hearing that was put in at a time when the evidence was not complete, and we were content to do that and to work around potentially late evidence. But the history of case management in this matter is significant from that point of view, particularly where it's said that the parties have been on an unequal footing, or it's suggested that there's been insufficient time to take steps. And I resist those submissions in the strongest of terms.
Well, yes. Well, I didn't. I may be over-interpreting Mr. Simlet. I didn't think he was pushing that point particularly strongly. I mean, he was 3 months, wasn't it? January, March, April, May, January, February, March, 4 months from Mr. Justice MacDonald, 3.5 months to the hearing.
Yes. The importance of that submission, my lord, focuses on the question of pain.
Yes.
Because my learned friend says that the neurological issues and the importance of the neurological evidence only became apparent as this case evolved. Again, I resist that submission.
Well, there was a neurologist engaged before the proceedings started.
Yes. And not only that, my lord, but both in the advocates' meeting and at the directions hearing, the issue was pain. And the reason that Miss Butler-Cole asked for permission to ask the clinicians questions was about pain.
And the questions were about pain.
Exactly. And when we discussed that, she said, well, I can deal with it in cross-examination, but the sensible way of dealing with that is by way of questions before we get to a hearing so that that issue has been explored. And significant, my lord, is the fact that that was to be explored not only with the experts, but also with the treating clinicians. So I struggle, my lord, to see how neurological evidence was not considered germane to the case, particularly in the context of this catastrophic injury that Alta sadly suffered, being a brain injury.
I haven't looked at the questions that Miss Butler-Cole put to the expert. Do we have those?
I believe we do have them in the bundle.
I missed them. We have.
They were particularly put, my lord, because there was an issue which was explored a great deal at trial about the question of...
Well, maybe they're in sub-statements. Are they in...
I'm looking for the reference, my lord, but one place they feature is in Dr. Hart's second report, where he sets out the question and what his answer is.
I'm very grateful to the learned friend.
Dot B. Dr. Hart.
Section D.
My Lord, similarly, with the second reports, Dr. A and B, they are both the questions from the parents and the guardian are set out.
So this is D. Is it D? Might it be D16? I hadn't focused on exactly what was asked on behalf of the parents.
I don't think we have got questions, actually.
You don't?
I don't think we do.
No. I don't think I've seen the questions, but they might have been incorporated in one of the reports in a way which I haven't discerned.
On D2, Dr. Samuels reproduces the questions which were put to him.
So Samuel's, it's D somewhere, isn't it?
D2,
D1,
which
D2.
is 328
Oh,
in
yes.
the PDF, if
Yes,
that
there
helps.
He's not Payne though, is he?
No, he's not. That's quite right. He's a respiratory paediatrician.
Well, I'm now at Dr. Hart.
D31. The Hart.
Thank you.
We'll wait for him.
Yes.
So here there are questions, yes.
there are.
And are they the parents? Are they Miss Butler Cole's questions? Yes, they are.
Yes,
Posed by Alice.
posed by Alfred's
It's there.
family,
I thought it was
D31,
there.
3.3.
Thank you.
And then Dr.
Right.
Hart goes on to answer questions from the Guardian, because questions were put from the family and the Guardian.
Well, they are about pain.
Yes.
Not all of them, but they're all around neurological functioning, which is what you'd expect. But E on D32, F, G, H, J.
Precisely so. They go to pain. That is why they were put, and that is the subject matter of those questions. One of the reasons that those questions were put, and that Miss Butler Cole was concerned to put those questions, and she flagged this at the directions hearing, was that in the initial application before the court, there was an assertion that Alta responded every time to gentle touching by going into spasm. And the family resisted that and said, she doesn't. Now, video evidence was produced to Mr. Justice MacDonald, which showed that she doesn't. That's fair.
Not every time.
Not with every, yes,
No.
precisely, not on every occasion. And interestingly, when we come to the new evidence, which is put forward now, that new evidence presumes that it is with every gentle touch that she goes into spasm. One of the critical points in terms of cross-examination, in terms of Dr. Hart's evidence, was that the consistent response is in response to painful stimuli. That is when she is...
Yes, hence the distinction between his evidence and Dr. Ross Russell's evidence, because Dr. Ross Russell hadn't used the nail bed.
He, supraorbital pressure is one, nail bed pressure is another. There are tests which are performed which apply painful stimuli. And one of the aspects which Mr. Justice MacDonald found to be significant was that there was a consistent response to painful stimuli, albeit not a consistent response to gentle touching.
Yeah.
And for Dr. Hart, that made a significant difference. That, in a sense, proved the theory that the pain probably was felt.
Right.
There is one area where Llewellyn Friend and I part company entirely, and that is on the question of the nature of the pain and its intensity. Because he submits to you that this pain must be unendurable.
Intolerable.
Yes, unendurable I think comes from his skeleton argument. Intolerable was the other classification. And one of my primary submissions to Mr. Justice MacDonald is that the pain need not be intolerable. That subjective assessment, of course, is very difficult because pain itself is a subjective experience.
When you say the pain need not be intolerable, that's sort of half of a sentence.
For what?
For what?
precisely for Mr. Justice MacDonald to weigh into the balance and say that that is, he says in, I forget which paragraph, I'll take you, my lord, and my ladyship's to it, but he says it's a significant counterweight. It's the beginning of 99. In Alta's case, I'm satisfied that the fact that Alta is in consistent pain acts as a very heavy counterweight to the presumption. So this is the question really of
No, just let me just check that.
Sorry, my lord, paragraph 99 of the judgment.
Well, this is the presumption of preserving life. Yes.
Yes, precisely.
91?
99. He
Sorry,
talks
you said 99. Sorry.
I'm sorry.
No, my
Perhaps
mistake. My mistake.
In the preceding paragraphs, Mr. Justice MacDonald is talking about the sanctity of life and the preservation of life.
Yeah, so counterweight to the presumption. Yes.
Precisely. And that is the other area that my learned friend and I part company on, because he says in his submissions to you, a significant burden should not be decisive. Well, a significant burden of pain, perhaps not decisive, but it must weigh very heavily in that sensitive balancing act which Mr. Justice MacDonald performed. My learned friend also says that the judge wrongly took spasms to be evidence of pain. I've addressed this to a great extent in my skeleton argument. It's at 4.22 on page 19 of the skeleton. And I've said there that it does a disservice to the judge's sensitive handling of all of these issues to say and it simplifies it unreasonably to say that he took spasms to be evidence of pain. He took very much more than just the spasms. And this is where it is important, my lord, that there is a distinction between painful stimuli and gentle touching and consistency of response. And the evidence below was that it wasn't just the question of spasms which was the burden of pain. There are a number of different factors. There was the burden of Alta's underlying condition, which itself produces pain. Mr. Justice MacDonald, as part of his assessment, looked to her prognosis and to the future and how that would develop, and he was satisfied that there would be further pain should her condition develop.
Worsening condition.
Precisely. Then there is the question of consistent response to painful stimuli. And there are painful stimuli. He heard evidence about blood tests being taken frequently and so on and so forth. And then and only then was the question of gentle touching and spasms a part of the balancing act and a part of the assessment of pain. That is not to say that those spasms are not significant. He heard evidence that those spasms are like muscular cramps.
Yes.
And that's referred to in his judgment. I've struggled over the lunchtime adjournment to find exactly where.
No, I've seen that phrase.
So it's not to say that those are insignificant. And he heard evidence that in children with cerebral palsy who can express how those cramps feel, they always consistently express them as being painful. So the ground of appeal which concerns pain grossly oversimplifies the exercise which the judge undertook. And as I've referenced in my skeleton argument, you will see the references to the various evidential points which he considered and the objective measures which he considered. On that point, my lord, the question of objective testing, you will see that there are EEGs, MRI scans. You will have seen, I'm sure, Dr. A's pain report, which includes images of the MR scans and explanation thereto. And as your lordship noted, in the court below there was a good deal of evidence and examination about the structure of the brain and what was preserved and what was not, and the pain pathways. My friend now says to this court that somatosensory evoked potentials tests should be conducted. Nowhere in the evidence, including the fresh evidence, are those tests referred to. And my learned friend, from that point of view, appears to be giving expert evidence. I'm not sure that anywhere in the neurological evidence I can find reference to those. And it perhaps starts to highlight the difficulty of attempting to adduce fresh, complex medical evidence, which no doubt is beyond my learned friend or me, without clear instructions. Having said that, because the submission is that those tests are absent to the court and they would assist the court and potentially be determinative of pain, I've taken instructions on those over the lunchtime adjournment. And I'm told, and this was the evidence in the court below, that no test will tell us what alters experience of pain.
And that's what the judge found?
Yes.
Well, that's consistent with this finding?
Yes. But I'm told that somatosensory evoked potentials tests will take us no further than we already are in terms of the MR scan, in terms of the EEGs, in terms of the very detailed and complex evidence which was below. Now, just as my learned friend may not give expert evidence to you, I may not either. But I submit to the bench that those are my instructions, and I have no reason to doubt those in the light of the evidence which was given below. And there was a great deal of cross-examination on all of these issues, as one would expect.
By Miss Butler-Cole?
Yes, by leading counsel who is extremely experienced
yes,
in these sorts of cases. So, my lord, I don't accept that the judge simply took spasms as meaning pain. I resist the submission that that should then be classified as discomfort. There is no evidential basis for submitting that that should be the case. And the judge...
Well, was the, weren't we taken to one expert who referred to discomfort?
My lady, that's entirely fair that there were different responses, and in fairness in the oral evidence as well, when Dr. B in particular was cross-examined, he was asked about the extent of pain in response to matters like blood tests.
It was Dr. Samuel's intermittent unpleasant sensations was the reference.
But oral evidence, you're saying Dr. B?
The oral evidence was Dr. B. But
so discomfort was used?
I'm sorry,
the word discomfort was used?
It was used.
On more than one occasion in the written and oral evidence?
Indeed it was, and the judge used the word and uses the word pain in his judgment.
And what's your submission on that?
My submission is that that finding of pain should not be disturbed, and there should be no question of substituting discomfort. The judge, in what is a lengthy and careful judgment, has clearly considered those evidential matters in detail. And he is and was best placed to make those assessments of the lay and the expert evidence. And as part of the assessment on pain, he factored in the lay evidence as well, the video evidence. And as an aside, my lord, on the question of the method of the hearing, clearly it is not the same as appearing in person, but I don't accept that there was any deficiency.
No, I don't think Mr. Simlet submitted there was.
No, there was a suggestion that there could have been photographs shown, that there was video evidence and a fair bit of video evidence.
Yes.
So from that point of view, the judge was able to take evidence of that sort, albeit it was a remote hearing. My lord, the issue of pain, the question of pain, I've always submitted, below and here, is central to this case. It was central to the case and it's central to the appeal. And I've submitted in my skeleton argument, my lord, that the grounds of appeal must be seen in light of the finding of pain. And where your lordship asks my learned friend, well, if we're against you on pain, is there still a case there? Would it be legitimate for the judge to find as he did and to perform that balancing act in the way that he did if his findings on pain are sound. My submission is once the judge's finding on pain is not disturbed, the rest of the appeal must fall away. And I submit that because in the balancing act, the careful, nuanced balancing act which he performs, and the intellectual exercise he goes through with the intellectual milestones, it is an appropriate finding. It's not only a finding which ought not to, doesn't give rise to grounds of appeal, it was the only sensible finding. You'll see my submission on pain is that. The inevitable finding in the light of the evidence and the weight of the evidence on pain was as he found. My Lord, that leads me on, unless I'm going to say something on pain.
I don't think so. Thank you. Yes, you'll move on to religion.
It leads me on to the question of the balancing act, and
Right.
specifically Articles 8 and 9. And it is fair to say that within his judgment, Mr. Justice MacDonald does not explicitly deal with those. My submission on that, my Lord, is that all of the parties made submissions on that, although he notes explicitly in his judgment that he did not receive detailed submissions on Article 9, nor did he receive detailed submissions on Article 8, but he did receive submissions on those matters, and those are on the face of the position statements of all of the parties. And my Lord, I acknowledge absolutely that Articles 8 and 9 have a significant role to play in this case, in this sensitive case, and I submit that the reasoning of the judge in the court below reflects the substance of those articles and the concerns which are now raised. It was submitted in the court below that this case had to be seen on the basis that Alta is a little Jewish girl, and that is the way that the judge approached this case.
Well, you say a little Jewish girl, a girl of a very particular and special community.
Absolutely. And it's quite clear from the reasoning of Mr. Justice MacDonald that he took that into consideration. He says so in terms. But your Lordship is, of course, right. It's not just a question of categorising her as a little Jewish girl. It is specifically the community to which she belongs. Whether that then means that that translates into Alta having possession of her own religion, clearly she does by birth, whether it means that she does in a cognitive way is something that the judge addressed, and it is a difficult assessment.
Well, but it might be said that one of the high water marks in Mr. Simbler's submission was the submission about the starting point and the last sentence of paragraph 95, which we're coming to that.
My Lord, yes, this is precisely the issue. So Alta, of course, then has her identity from birth. But what the court goes on to consider is whether or not, given that she has never had any cognitive experience at all, whether she then should be taken to share those values and those beliefs.
Well, what Mr. Simbler puts, and I'm going to put it much less elegantly than he did, is that it's not a question of cognitive abilities. It's the fact that she is who she is, and she is a member of this community, and therefore has those values simply by reason of who she is, not what she understands.
Well, and I would say it's both of those issues. So I would say that's absolutely correct. I would submit it's correct under Article 8. And that is where Article 8 comes in, and it is enmeshed in this case with Article 9. But that of itself is not where the matter begins and ends, because one must also consider, the court must and did consider, whether or not Alta would then share those beliefs and choose to adopt those beliefs as she grew as an individual, and whether she would be capable of doing that. And those are two different and distinct issues, although I quite accept that they are enmeshed.
Well, when you say capable, are you submitting that because of her disability she would never be capable of knowing and understanding?
In the case of this child, yes, because she has never had a cognitive ability at all.
Well, to which Mr. Simlet might respond, why should a child who lacks the mental capacity be treated any differently from one who has it, when you're looking at this element?
The difficulty in that submission comes then in the balancing exercise, because this child, if that's taken to its logical conclusion, may be in a worse position from the point of view of pain, and whether this child can take on the concept that it
We're
is...
taking pain as a given in the balancing exercise. We're looking at two children, one of whom has the mental capacity to understand and one of whom doesn't. Why should it, Mr. Simlet might say, or he does say, why should they be treated differently?
Well, and if you'll allow me, my lord, the question of pain is relevant to that, because in terms of the spiritual being of Alta, and in terms of whether or not she would choose to prolong her life and have that suffering for spiritual benefit, is exactly the assessment. And that is being conferred on her in a way that in my submission...
Say that again, would you? Just repeat. I was listening and not writing. Just say that again. If you can.
I'll try. The question of pain is germane to this in my submission, my lord, because there is, and Alta's religion is not the only religion that would consider this to be the case, that there would be a benefit in enduring suffering for spiritual gain. Because once the finding of pain exists, that is there. And as you know, it's my submission, that shouldn't be disturbed.
How does that answer my lord's question?
You've got a child with two children, one with mental capacity, one without.
Yes. In the case of a child with mental capacity and with a cognitive ability, they would be able to some extent, be taken to be able to undertake that assessment.
We're not dealing here with the Mental Capacity Act. I'm going to be doing this from memory because I haven't got the Court of Protection book to hand. But if you're looking at a person, necessarily an adult, suffering a mental incapacity, and you're looking at what's in their best interests, you have regard to their wishes and feelings, values, and there's another word, my mind's gone blank. And it's not, so if it's the case that with an incapacitated adult you have regard in some way to their wishes and feelings and values, why shouldn't the same be true of a child? Because I don't think the judge went down this track.
No, the circumstances in which those assessments might be made under the mental capacity are very varied. And there would be times when the evidence would be all important, not only of birth and of religion taken from birth, but of that person potentially before they lost capacity. So that is a distinction in my submission.
If it assists my lord in formulating the question, Section 4 is in of the Mental Capacity Act is in the legislation at the end of the order.
Well, that's very, very. Shows good foresight by somebody.
Tab 29.
Thank you.
In the fund of
Tab
2 of the
29.
warrant.
Thank you. Thank you for sparing my blushing.
Well, I was looking it up myself just then.
There we are.
And this, in a sense, my
This is the Mental Capacity Act. This is the best interest. So this is a bit like the welfare checklist, not the same, a bit like the welfare checklist. And it is...
My lord, at paragraph 6,
Mm-hmm.
so paragraph 4, best interest, subparagraph 6, and this perhaps addresses the point which I was seeking to address, the person's past and present wishes and feelings, and in particular any relevant written statement by him when he had capacity, that's a distinction in those cases.
Go on, though, to be.
Yeah, that's
Yes. And the beliefs and values which would be likely to influence his decision, absolutely. It is a part of the assessment. Whether that translates into then taking parents' belief system and their values and superimposing them absolutely on the child is questionable.
Well, that is not how Mr. Simbitt put it. It's not a question of superimposing. It's the child is born to this community. It's the way the community functions. The child is born to this community, and this child would have acquired those values without doubt, Mr. Simbitt would say. That might be putting it too strongly, but in a high degree of probability.
Well, the without a doubt does put it too highly in my submission, because Alta is her own person. She is an individual.
Oh, but the parallel here would be likely to influence.
Sorry, my lady.
So
Likely to influence.
Would be likely to influence. So if that's the parallel, that would be the approach here. So it doesn't be bound to. Would Alta be likely?
Yes, that would be the assessment. The exercise, of course, was approached by, and I accept, of course, as does my learned friend, that we have to be cautious in looking at Rakib. But the distinction which was drawn there was that that was a little girl who was by then practicing her religion to some extent, and she had a prayer mat and so on and so forth. So that was a difference which Mr. Justice MacDonald took to be a significant difference. But I accept that the fact that Alta is born into her religion is significant in the balancing act. Whether that is significant enough to displace the weight which Mr. Justice MacDonald puts on pain is what I question.
Yeah.
But the point is that the suggestion is that the judge placed inadequate weight on Alta's putative beliefs. And it wasn't just a factor, it was a really important factor. What do you say about that?
I acknowledge it was a really important factor, and I acknowledge that he does not address this balancing act and this enmeshing of Article 8 and Article 9, which we now talk about.
Expressly, but you say he does the...
I say he does implicitly.
It's not as a question of... I mean, if it's a question of weight, then that might be harder to challenge in this court, but Mr. Simbitt doesn't say it's weight. It's a question of the starting point was wrong. So if he started the wrong place, then it's not just a question of the weight, it's the whole approach, a broader criticism of weight.
The whole approach in my submission was sound. So where Mr. Justice MacDonald sets out the list which he does, firstly, that's not his analysis, it's an analysis of the law. The learned friend refers to that in his skeleton argument. And then he adapts it specifically to Alta. So if I might take your lordship and your ladyship's the law is set out at paragraph 56 of the judgment onwards. And then we come to, in paragraph 66, where Mr. Justice MacDonald considers exactly this issue. And in the final sentence of that paragraph, he says this: within this context, Mr. Dr. Cole and Dr. George submit that the assessment should start from the assumption that Alta would share the values of her parents, her brother, and her wider family and community. He goes on to factor that in and says at paragraph 31...
Does he accept that?
At paragraph 71, he deals with it. So at 71, he says, I have no hesitation in accepting the submission that an assessment of the various dimensions of Alta's best interests must take into account the particular religious, cultural, and ethical context of this case, provided by the fact that Alta is an Israeli citizen, the fact that the family intended to emigrate with Alta to Israel, and the family's Orthodox Jewish beliefs, and that the assessment of their best interests must be informed by consideration of the religious, cultural values of the family, and by recognition that religious and ethical frameworks governing these subjective factors differ. So that, in my submission, is
well, that's not quite... That's not
however.
Yes,
yes.
He then says, it's, however,
yeah.
matters remain simply factors to be placed into the overall best interests evaluation. And in my submission, he is entitled to do that. So the concerns that my learned friend has in my submission are dealt with at paragraph 71. And then in 72, he goes on to talk about the factors in the overall balancing act, in the overall best interests assessment.
No, but you need to deal with the penultimate sentence, which is the target.
Yes, one factor.
It's just not. It's incorrectly downplaying it to a factor, as opposed to being a really important factor, or one of the uppermost factors.
Well, and that if this court is dissatisfied with the judgment, it would have to be on the discretion and the balancing act. I say that that's an appropriate assessment, to take it as one of the factors, and not to take it as the overwhelming factor. And that's perhaps where my learned friend and I differ.
Well, it's actually made clear in the last sentence of 72, which prefigures what's going to come later on.
Yeah. That it should start from the assumption that she would share the values.
Why is that right? That's it. Why?
The reason in my submission that that's right is because of what the judge then goes on to consider in paragraph 96 of his judgment. And this is the question really of being...
It's where he comes back to it, isn't it?
Exactly. Whether being born into a religion is sufficient to make that an overwhelming factor or the starting point of the best interest assessment. And this is where the judge talks about how far the court can safely go on that.
So I suppose you would say that if he was required by statute expressly to consider the beliefs and values that would be likely to influence Alta's decision, if she had capacity, adopting the words in section
Yes.
4B of the Mental Capacity Act, that he does that because he accepts that it is how he deals with it. In 96 it does address it in the, or not quite in those terms. I'm satisfied that where she's not developed any understanding of the faith in which she's born, etc. So he does take into account what her values and beliefs would be likely to be.
Yes.
But concludes they're outweighed. He finds more likely not they would be outweighed in her case.
Precisely so. He does not discount that element of Alta's identity at all in my submission.
Well, let's just pin down what you mean by that.
Well, that is
not just her parents' beliefs, but
Yeah.
what her beliefs would be likely to be.
Yes, precisely. So those are two separate things, and the fundamental issue for Mr. Justice MacDonald was Alta's beliefs.
It's
The way that sentence is structured is not quite as you would like it to support that submission. I'm not saying it doesn't, but it's because he doesn't say, I take into account that she's likely to grow up. She will be likely to have the beliefs and values of her parents. I'm taking it in shorthand, forgive me. Yeah, but it would be more. It's more likely that would be outweighed by pain.
Yes.
It's kind of. He says that in circumstances in which she has not developed any understanding of the faith, etc., it's therefore it's outweighed by pain.
Yes. It is a different emphasis, and it would be perhaps preferable to have expressed it in the former way. But, my lord, my submission is still that it is taken that she is born into the religion, it's taken as read, and then he goes on to say the furthest he can safely go is that the child's attitude may be and often is influenced by the views, beliefs and guidance of the parents.
Yes.
So
So he reiterates the point he makes earlier in that paragraph, at the top of that paragraph. Sorry, I interrupted you.
No.
But he doesn't, I acknowledge, he doesn't say that that's the starting point or the paramount issue, and then go on to say that the pain outweighs.
Can I ask you the point that's slightly troubling me about that paragraph? I mean, it's the first sentence of 96. Is it right that he was in a position where it was absent any evidence to assist the court in determining the extent to which Alta would adopt wholesale the views of her parents? I mean, the fact is, without making any judgment about whether it's right or wrong, the fact is that most children, the vast majority of children who grow up in a Hasidic community, maintain those beliefs. There are issues about that, but that's the fact, isn't it? So when he says he didn't have any evidence, can't one say it's probable that she would?
He had evidence that Alta would have been brought up in that tradition.
Yeah. What evidence are you going to get in a situation like that, other than what you've got here, which is the brother, the
Family.
the fact the family would bring her up, the fact that every single member of the family seems to remain within the community, on the evidence that we've seen. What evidence could one expect there to be on this issue?
In a sense, that would be
That
precisely...
there was not.
My lady, yes, that is precisely the issue which Mr. Justice MacDonald had to grapple with then evidentially, because the best evidence then is simply that...
I mean, for my part, I'm just testing your submission. I'm not indicating where our mind is going by these questions.
No.
It's just testing the
Likewise.
assumption.
Likewise.
But
isn't he in paragraph, the first sentence of paragraph 96, picking up the analysis in paragraph 95,
it is.
where he's contrasting the situation of Alta with the child in Rakib, because there was some evidence. So when he's talking about no evidence, he's saying, well, look at Rakib, there was some evidence there,
Yes.
the evidence that you've alluded to. But in this case, there isn't and can't be any evidence of that kind because of the condition that...
Yes, that's right.
Yeah.
In that case, there was a word concrete.
Yes.
What's the word I
So I
want?
think
Evidence.
maybe what he's getting at.
Yeah.
And in fairness, that is probably in part because there were lengthy submissions about Rakib, perhaps not surprisingly given the issues of international transfer which arose in that case.
Yes, that's right. But okay, we're probably distracting you enough. What's your next submission? I'm distracting you enough. Sorry. That's really it. That is the. For my part, that's the point. If there's a concern in this judgment, that's where it is.
Yes.
On the way he treats the religion. If there is.
Just briefly before we move on from that, if I may, it is in my submission a question of then the individual, the child, and tailoring the exercise to the child. And where my learned friend says if Alta was asked, this is what she would say. And she would say, when I'm gone, I would want to give my parents no more anguish. That takes matters too far in my submission. It's assumption.
But it's an assumption based on the culture, the strong evidence of the very...
There is two...
trying to avoid a pejorative word. I don't want to say rigid, it's the wrong word. Very strict way that children are brought up.
Yes.
In that community.
That strictness.
And it's not for this court or any of us to be judgmental about that.
Of course. That strictness should not interfere with Alta's individuality or the assessment that the court undertakes. And there is a risk where there is a finding of pain but then she may be in a worse position because of assumptions that are made on her behalf.
But isn't there a danger that you're imposing Enlightenment values on rationalist Enlightenment values on that assessment?
Well,
in saying that, again, I'm just testing you.
in my submission, not. Bearing in mind always that one has to be aware of one's unconscious bias as well as conscious bias. The judge, in my submission, in his judgment, shows that he is aware of that. And the sensitivity with which he deals with those matters reflects the fact that even if the submissions had been put in the way that they are now, the assessment would be the same. And that has to be seen in my submission in light of the finding on pain.
Well, I think at the moment for me it's clear that Miss Butler-Cole and Dr. George did put the case pretty much in a similar way on this issue.
That's fair, yes.
Not in the same words, in a different style, no doubt. But the essence was the same.
My Lord, yes. On the issue of dying, if I may, and the question of Article 8 and the religious imperative to be buried within 24 hours, evidence was given on this matter. And the issue, my Lord, which was, as it was explained by Rabbi Goldberg in the court below, was that the ideal is to die and be buried in Israel.
Yes.
But that it would be possible for her to be buried in Israel were she to die here.
Well, there are hurdles that have to be overcome. It's not impossible.
Well, and it's for that reason, in my submission, that in making his declarations in the way that he did, and in the way that he addressed it in paragraph 111 of the judgment, Mr. Justice MacDonald was sensitive to those issues and addressed the question of the Article 8 rights which attach to that from the point of view of the parents. There is, of course, an interesting question about whether or not the best interests assessment involves consideration of what happens after death. In my submission, in this context, with this child, that is a legitimate part of the best interests assessment in light of the cultural, religious requirements that we're dealing with. But what is said in that context is that ideally it would be a question of dying and being buried in Israel. And we are not, of course, dealing with an ideal situation, we're dealing with a tragic situation. On that, my Lord, there's a question of, my own friend says, withdrawal will happen in the intensive care unit. Actually, discussions were to take place about where that would happen. And those discussions will. So it's not a given that that is where matters will take place, if indeed that's the decision of this court. I appreciate those are acutely sensitive matters, but it's not right to say that it is paediatric intensive care or Israel.
Well, I imagine in making that decision, the parents would have to have regard to all sorts of things, cultural issues,
Absolutely.
Their community, have to consult their community, I expect.
Yes.
So
Those on the part of the trust, to the extent that they can be, will absolutely be accommodated. My Lord, on the question of transfer, I don't know whether your lordship's.
well, you've covered that in your document. Okay. Do you want to ask any questions about transfer?
Don't know whether I can assist any further.
Thank you very much. Ms. Holloran.
My Lord, my ladies, if I can just start by just referring to one matter before I forget, and it is simply the assistance of the court, and that is in relation to section 1(2)A of the Children Act. The explanatory notes, part 2, paragraph 11.
What are you reading from?
Pardon?
Explanatory note to what?
Explanatory notes to the Children
And Families Act 2014.
Make it clear that that paragraph is in fact sending a clear signal to separated parents regarding the involvement of a in the child's life. Of course, with the rider in the explanatory notes, that is where it is safe and consistent with the child's welfare. So, my Lord, just in relation to assistance on that. My Lord, I would just also comment very briefly on the observation made at the beginning of my legal counsel for the parents in relation to the venue of the way in which the hearing in the first instance was conducted. There was throughout an option to attend in person, and it was intended that that be an attended hearing, both in April and again when we listed in May. That was not.
Was Mr. Justice MacDonald sitting in Manchester at the time, or
he was sitting in London?
He was in London, so it would have meant the family coming to London.
It would, but it was an option at that time, and all parties were.
Okay. I wouldn't worry about the observations I made earlier. I don't think that's a big feature in this case.
I, of course, have again provided written submissions.
Thank you very much. Very helpful.
Of repeating those to any degree, and I will only address my Lord, my ladies, to the extent that it is of assistance to the court. If I can start then on the issue of the pain versus discomfort dichotomy that is.
Well, we've heard what Ms. Mulholland says about that.
Yes, but it was a matter that was explored in some detail. Dr. B in particular was pressed regarding the distinction between pain and discomfort of some interventions for Alta, and for example was asked about blood taking, which happens on a not infrequent basis. He conceded very readily that the act of taking blood from Alta would not necessarily be painful. That is an act which might cause discomfort, but it is also an act which might trigger for Alta a spasm or a tonic-clonic seizure, which would be painful, and he made that very clear distinction between the act itself and the impact on Alta. Dr. Hart, in cross-examination, was asked about the extent of the experience for Alta, and likened it to a muscle cramp by somebody who had just run a marathon, and in that context, again, was describing the muscle cramps as painful, perhaps at an extreme level on occasions. Dr. A, paragraph, who is set out at paragraph 26 of the judgment, and Dr. B at paragraph 25 of the judgment, were very clear that these are painful experiences and not simply experiences of discomfort. And Dr. Russell, of course instructed by the parents, said in terms both in his report and in his oral evidence that children who can express this experience articulate it as pain. So both within the report and in oral evidence that was explored in full, and there was certainly no suggestion confined to an experience of discomfort, but rather that it tips very clearly an experience as opposed to necessarily a feeling of pain. If I move on then to the question of Alta's religious faith and the extent to which that should have been put at front and centre of the considerations. Of course, whilst the observation has been made, whilst not specifically referred to, the welfare checklist is at the forefront of any consideration alongside the balancing exercise undertaken in determining the best interest, and in both child's welfare it is absolutely paramount. There is no suggestion paramount importance. And it is a question in each and every case of going through every element of that checklist and every element of the best interests test, and constantly conducting a check and balance as to the extent to which, in the case of this particular child, those factors have a bearing and an impact on the outcome and the determination and the ultimate decision, and based firmly on what is in this particular child's best interests. My lords, my ladies, you have been referred at some length to the considerations of those matters within the judgment. I have referred at page 11, tab 10, page 11 of my skeleton. I don't think this authority has made it to the authority bundle. No, I don't complain. It's an old authority, and it's expressed very briefly, and there is little more that would have assisted within it.
Thank you.
At the bottom of page 11, paragraph 3.4, that deals quite clearly, and that whilst some faiths recognise religion as a birthright, as indeed does ours, and that has been accepted on behalf of all parties throughout, this is ours birthright. A child's perception of his or her religion generally depends, and this is over the page, on involvement in worship and teaching within the family, and from this develops the emotional, intellectual, psychological and spiritual sense of belonging to a religious faith. It is not therefore quite as simple as saying, had Alta been a child who had been able to be brought up at home within this quite clearly loving family, would she have been a child who would have followed the tenets of her parents' religious faith, certainly until at the very least, early adulthood. That is not in dispute, and my lord, I have to say, given that it was not in dispute, I think it has to be read as absolutely implicit in the judgment that was something that was accepted. Of course, that is very different from saying when one is looking at the child's wishes and feelings, and as his lordship was in the lower court, attempting to put himself in the shoes of this child, whether he could accept that this child, with all the burdens that she is experiencing, and with her absent, incomplete, I don't think covers it, but her absent understanding of what her religious faith means for her, would she have decided to bear the burdens of her treatment when weighing them up against the spiritual benefits that she would have obtained from enduring that suffering? And he was assisted by the children's guardian, who had prepared a very detailed report, and he ultimately reached the conclusion, albeit, and I accept, very briefly expressed, that when looking at matters from the point of view of Alta, he could not be satisfied that she would have accepted that burden for all the reasons why the parents, with their far more evolved understanding, with the pressures that must inevitably be brought to bear in being part of that community, but which the rationale behind the parents' decision making and the parents' decision making received the utmost respect and consideration before the lower courts. It was the focus almost entirely of their evidence. It was the focus of the rabbi's evidence. The children's guardian deferred filing her report until she was able to speak to the rabbi in order to have that understanding for Alta of what it would mean to her. But ultimately, the evidence before the court is that it means more to the parents than it could possibly ever mean to this profoundly disabled child, whose experiences of life to date have been so limited and so rooted in endurance of intervention and pain, and the fact that the focus of his lordship's concerns centred around that point is, in my submission, above reproach. There is no justification for elevating any element of the welfare checklist above any other. Each is taken in turn and each is given its own weight.
In the circumstances of each case.
There must be different weights in different cases.
I mean,
absolutely.
the fact that
in each case. I
yes.
apologise.
No, that's, yes, my lady's right.
Yes, in each case, different elements.
And in some cases, a magnetic factor.
Absolutely, and in some cases, in the case of an older child, wishes and feelings will be determinative. In cases of younger children, with or without Alta's profound.
If we're putting this into the checklist, I don't think it's so much wishes and feelings. It's background.
It's background and characteristics, absolutely, and I think I've acknowledged that within my.
Which isn't a factor, which features very often, actually, in welfare checklist analyses, if you see as many of them as I do. But in this case, it seems to me to be crucial.
It is crucial, and I don't in any way suggest that it was not an important factor, but neither do I accept that it was a factor that was given insufficient weight, given that the submission that Alta is rooted in the Jewish faith comes from an understanding of her parents' perspective as opposed to hers. And there was, as I've said, and I don't want to repeat myself, a great deal of attention and consideration given to the perspective of parents.
The way you're putting it, the way you're putting it is not the way the family sees it. It's not the way that the parents see it, that she has a perspective, even though she'll never be able to articulate it. She has a perspective. It's part of her background. It's a factor that should be taken into account.
Yes.
Irrespective of what they think.
Yes, and I accept that it would be a high test for her religious perspective to be the determining factor against the weight of all the other evidence. But even if it had been accepted that this was the first feature and the most important feature, I suggest that the hurdle could still not have been overcome when looking at all the other factors which cannot be excluded simply because one feature of Alta is given more prominence than the other, and taken together those outweigh the very real and understandable views of the parents regarding her, the importance of her religious culture and background. It simply cannot be assumed that Alta, when faced with her very challenging circumstances, would have herself prioritised her religious beliefs, and that ultimately it was for the court, as has been made clear, to make decisions in her best interests from her perspective, weighing up each view that she may have and determining ultimately which one is in her best interests. My Lord, I'm not sure I can assist you further. If there is anything that you feel that I could do.
No, thank you. Thank you, Mrs. Holman. Mr. Siblett, before you say anything else, Mr.
Yes, I would.
Mr. Liu looks
I would
looks
like
about
to
to
come back, and
approach.
I would like to see what Mr. Liu and my solicitor are wanting me to raise.
All
as
right. Well,
so
do take
I'll just
take instructions.
Turn my back if I may.
Rise.
We'll rise. Well, I don't think something to say. Do you want to talk before we? A little talk before we finish. What do you think? Mr. Siblett, would you like us to rise for a couple of minutes just while you? Yes.
Mr. Liu says yes.
Mr. Liu says yes. What would you? What would Junior say, Mr. Siblett?
Ready when they are.
Hot right. Okay, Mr. Sibbett, what do you want to say in reply?
Well, my lord, in relation to the question that you asked, in relation to what the Mental Capacity Act says, in section 4, it is framed in terms of what is likely, and we say not just that the judge was wrong to say that there wasn't any evidence. The fact is there was plenty of evidence, and there was nothing, in fact, to gainsay that. So the likelihood of whether Alta would have followed the Hasidic rules and practices, and likelihood of whether she would do what that system of practice, what those cultural practices mandate, easily, in my submission, satisfies the comparable test under section 4. Secondly,
sorry to interrupt, Mr. Stewart. Can I just, this is just my ignorance. Is section 4 the relevant test though here?
well, there's some discussion in Rakib about the appropriateness of trying to, as it were, put a person without capacity who has may well have, but not in every case, lived some life, so there's some past experience to compare it to, and so on. But it is, and in my submission, it's not of direct application, but it is of a comparable jurisdiction of asking a court to step into the shoes of a person to decide what that person would do.
Parliament has created the section 4 test in relation to incapacitated adults. So at the moment, I'm just not quite clear how it applies when what you're dealing with is the best interest of a child, and that's what I'm asking for your help with, please.
Well, my lady, I think I'd put it this way. It's the same sort of deductive exercise of trying to put yourself in the shoes of the person, and indeed Mr. Justice MacDonald precisely uses that word at one point. He says it's difficult for a judge to put himself in the shoes of a 2-year-old girl. So he certainly draws the comparison with the exercise that the court, in a court of protection case, is asked to undertake under section 4.
But I think what you're really accepting tacitly is that section 4 is not the relevant test.
Well, no,
I'm sorry to press you, but I just want to understand.
No, that's...
It's not the relevant test. Milady's right.
It's
not the relevant test. And to some extent, it's my fault. I apologise to my colleagues for distracting you by turning the argument, by raising it.
Right.
It's an interesting... Picking up on Milady's point, I mean, it's not how section 1, subsection 3 of the Children Act is couched, nor for that matter the equivalent welfare check in the Adoption Act, Adoption and Children Act, section 1, subsection 4. So it's not there.
Yes. But when you come to background, which is there in section 1.3, the difficulty the judge has got himself into is twofold. The first is, and this is coming back to paragraph 72, which my learned friend was asked about by the court. The judge does two things in section 72. The first is that he rejects the contention that that he rejects expressly in the middle of 72 the submission that the best interests decision making can and must be framed within the Jewish belief system in this case. Well, point 1 to make about that, he rejects an important part of background. And section 1.3 says you do look at the child's background. And
That's not quite right, is it, Mr. Simblett? Because the submission he's rejecting is not a submission that makes the background irrelevant. It's a submission that gives priority to the background, which is a different point.
No, can and must be framed within the Jewish belief system in this case. I understand. Of course, I understand. If my lady takes it that it was only rabbinical law that felt to be applied, then of course I understand the point. But the starting point is framed within the Jewish belief system, and that is a part of background. This girl has a background of a Jewish belief system within her family. And then they say, and in fact, Mr. Justice MacDonald confines that in the next sentence to the parents. Rather, the Jewish belief system followed by the parents is one factor to be weighed in the balance. Now, that's a problem because it's not just what the parents think, it's how Alta's background would come about, because one's background is influenced by one's parents. And there's no evidence that she wasn't going to do that. And that's why the second point from 72, and that's how we then end up with the wrong starting point when we move to 95 and 96. For reasons I'll come to, I'm likewise not able to accept the submission that assessment of Alta's perspective should start from the assumption that Alta would share the values of her parents, of her brother, and of her wider family and community. Now, if there had been, in this case, a lot of evidence of Alta rejecting the mores of that community, then that would be one thing. But where there isn't, and we're talking about a baby born into a community, every member of which, to pick up a point my Lord Justice Baker made, where every other member of the family is part of that tradition, belief system and mode of living, where the brother dresses in the way that he does and interacts around his parents in the way that he does at his age, then it is not for Mr. Justice MacDonald to sit speculating as to that this is some improper assumption. It is in fact the only proper assumption. And when we relate that back to section 1.3 and background within the welfare checklist, pausing there, pointing out that Mr. Justice MacDonald never once himself expressly referred to section 1.3 and the welfare checklist, so we don't know to what extent.
Well, he clearly has in mind the background. I mean, if you read these, you read paragraphs 71 and 72. I'm, for my part, wholly unpersuaded that he didn't have background in mind. No. That's not. I don't think that's your main.
That's not. Yeah, it's not my main point. But when we're coming to allocate to the application of that and allocation of weight, it both seems to it informs his wrong starting point, and it also means that he's not able to do the exercise that my learned friend Ms. Holleran was contemplating of giving each weight equal factor. Each factor equal weight, which of course is not what you should do. You should go through the list of factors and decide which weight to give to which factor.
That was her submission. I think she was, as I understood her submission, she was saying the decision maker gives the weight to each factor which is appropriate on the facts of the case. Maybe I misunderstood.
Well, no, it may. Well, I'm sure that's.
Yeah, she did.
That is right. With respect, of course, but the problem. It's not just a problem of expression, because he very avowedly and deliberately says the same thing at the end of paragraph 95 and 96, as we've looked at. I'm not going to go over it again. But essentially, if that is right, then a disabled child is deprived in the welfare checklist of a proper assessment of her background. Secondly, this is not a community or a family that start necessarily from the position of deducing whether they wish to believe in God. They start from the assumption that God controls everything that they do, and their religion dictates their approach to their whole life. So to expect, as Mr. Justice MacDonald had in 95, her to an exercise of Alta sitting down to sort of work out whether she agrees with this or not, is essentially wrongly to have removed background from section 1.3. And in this case, background was not just a part of the welfare checklist, but in my submission, a core and very important one. And
I don't think you're right if you're saying that the judge did not take background into account.
Well, he didn't.
He plainly did.
He regards it as an aspect of what her parents think, rather than of who Alta is. That's my submission, and that's like how he's expressed himself in both 95, 96, and 72.
Well, it's not how he's expressed himself. Actually, he hasn't said in terms of who she is. That whole characterisation of the argument is part of your skillful advocacy, Mr. Simbley.
Well,
it's not how he's put it.
Well,
and I'm just trying to see. I would look again exactly how he put it in 95, 96.
Well, in 72, rather the Jewish belief system followed by the parents is one factor to be weighed in. I'm unable to accept that you start from the assumption that she shares the values of her parents, her brother, and her wider value and community. So that is saying she doesn't have the same values as those from her background.
No, it's saying that he's unable to accept the assumption that she does. So I think he's been quite careful about his words.
He doesn't...
and he's unable to proceed, unable to accept the submission that the assessment should start from the assumption. Start from the assumption. But he absent evidence, 96.
Yeah.
The furthest I can go is that it's likely that her attitude may be and often is influenced by the views and beliefs and guidance of parents.
Yeah, so having decided he won't take that as his starting point, he then declines to draw the inference that despite everything, despite there being evidence, and you've already made the point, my lord, that he's italicised any evidence when in fact there is evidence. Despite there being evidence, he doesn't, when placing himself in Alta's shoes, he only says it may be influenced by the views, beliefs and guidance of her parents. So again, it's about her parents and not about her and her being a member of this community in her own right. So to pick up the language of Ms. Holleran, she as an individual, it is in fact the individual starting point is she is one of this community, not just what her parents tell her to do. And whereas Mr. Justice MacDonald approaches it, one, as a sort of cognitive or reasoning exercise as to whether she does or doesn't believe her faith, and two, imputes its importance only to being the values of her parents and not of her. And insofar as he imputes it to being the value of her parents, he's rather downplayed that when he comes actually to put them into account, because then he says, well, of course, parents are often coloured by emotion, rather than actually thinking, well, if she hadn't got this disability, how would she live her life? And seeing, as in my submission can reasonably be assumed, that she would grow up in the same way and with the same values that her older sibling has. So that's the reply I want to make on that. There are some references, since we revisited pain, there are some references that in my submission say that my primary submission on pain, that the elision between pain and discomfort is a fair one. For your note, C117, paragraph 3, Roman 9. C114, the word used is pain and discomfort. And then in the pain report, which is at C124 to 132, the basis of the science in it, and what is at C131. And to clarify the submission that I was making about that, not only is there an interchangeability in language in the reports between pain and discomfort, but the point is the evidence of the intensity of the pain. That nobody suggested that this was very acute in the way that we might think about it. So when you come to putting that in the balance, and as Mr. Justice MacDonald did, treating it as decisive, that is highly relevant. I should also, I'm conscious of not going back too much to Rakib, but just to correct a point or make good a submission that I made earlier in relation to the science of this. In Rakib, exactly the paragraph 21, you can see that the exactly the testing, the somatosensory testing that I referred to as being absent in this case had been undertaken in that case. So the simple point I make is that there are the cogency of the evidence of pain in this case did not have the same definite scientific underpinning that is available and sometimes used and has been used.
The paragraph number again?
21 of Rakib.
Thank you.
Well, subject to the point that I put to you before lunch.
Well, yes, yes. I appreciate my lady's point about the difference in the measurements of brain activity and so on in that case. But my simple point is when it was submitted that no test can tell us definitely whether AF is in pain or not, which was the submission made on my right. There are some tests that can be carried out. For instance, Rakib, that had happened, and it hasn't happened in this case. But that's as far as that point goes, and I completely understand Lady Justice Laing's correction to not putting too high a premium on what we can see from the testing in Rakib. I'm just turning my back to this one.
Mm-hmm.
No, those are my submissions in reply. Thank you for the indulgence from the court.
Anything else?
No, thank you.
Thank you very much.
My Lord, just in terms of indulgence from the court, I rise not to make a detailed submission, but simply to say, and I should have dealt with this when I was on my feet and attempted to, at the point that Lady Justice Laing raised about the question of Mental Capacity Act versus the welfare checklist. And there is an analysis of that in Rakib, whilst appreciating that will not bind this court. It may be of assistance to the court, and the reference is paragraphs 121 and 122 of that judgment.
Well, I've read this judgment many times, but it's quite a long judgment, and not all of it sticks.
I slightly struggled to find it when I was on my feet, but those are the...
121 to 122?
Yes, and that was the question of whether or not the beliefs and values should be given something like preeminent weight. And the suggestion was that if the Mental Capacity Act test is adopted... I'm sorry, I just realised I'm speaking with my mask on.
That's the worst
Sorry.
thing that's happened to you. Yes. No, well, thank you.
It's just, as a matter of record, it
Thank
may
you.
assist the court to have those paragraphs.
But it rather makes the point that the lady was putting things to symbolize, which is no way you know. Thank you very much. Well, I'd like to say on behalf of all of us how extremely grateful we are to all counsel for their efforts in this case and their instructing solicitors, all of them. We're very grateful to you. This case has been extremely well prepared and extremely well argued, both in writing and orally. There's another point before I go on with my next point. I think Mr. Liu's getting further instructions.
My Lord, forgive me. I just want to make sure that
Since it's a point that's been raised by my clients, I will just mention it. Going back to Rakib and understanding the points that are made about the different evidence that there was about pain and so on in that case. At 175 and 174 and 175, when Mr. Justice MacDonald was unsure about whether the child was suffering pain and therefore didn't make the positive finding that she was, he did, notwithstanding the evidence that she would be, to use his words at the bottom of that page, increasingly burdened by pain, he decided that while pain cannot be entirely ruled out, therefore the court should proceed on the basis it's better to err on the side of caution. This does not maintain fidelity to the applicable standard of proof. So essentially, where the outcome was so grave that the court needed to err on the side of caution. That's a point that needed to be raised because my clients have raised it.
Yes, thank you very much.
Thank you.
Once again, I repeat what I said. I'm very grateful. We're all very grateful to you for the work you've all put in on this case, which has assisted our difficult task. We're going to reserve judgment, so we're not giving judgment today, nor are we going to give our decision today. We want to think carefully about the matters you've put to us and reread the papers. We will be handing down judgment. That means judgment will be handed down at a later date. A draft judgment will be sent out to council as soon as it's ready for correction of typographical errors. It's not an opportunity to re-argue further points, but just to correct us where we've made typographical or minor factual errors. And then once we've had your comments back, we will arrange for the judgment to be handed down. No attendance will be required. It'll all probably be handed down under the current COVID restrictions protocol. When it is handed down, it's likely that there may be some consequential matters to be reduced into an order, which we'd be grateful if council would agree. Thank you very much.
So I'll end the live stream now, and the 90-second delay starts